We are honored that Justice Kagan has graciously agreed to participate in our conversation with the Justice Program, as she has most graciously done every year that she's been liaison to our circuit. This year, Program Chair, Arizona District Court Judge Michael Liberti, and Cynthia Jones from the Western District of Washington and Chair of the Lawyer Representatives Coordinating Committee will be participating in the conversation. If I can have them please join the stage at this time. Decided to put some separation between myself and Justice
Here, no,
Kagan.
we're going to do it.
It's a little, it's a little much. It's a bright day today in the Ninth Circuit. Okay. Now I have the privilege of introducing our special guest, Associate Justice of the Supreme Court of the United States, Elena Kagan.
Thank you.
Justice Kagan was born in New York, New York in 1960 to parents who were the children of Russian Jewish immigrants. Justice Kagan's mother, she explained at her confirmation hearing, didn't speak a word of English until she went to school. Still, though, her mother went on to become a legendary, albeit very tough, teacher, and her father practiced as an attorney in New York. Justice Kagan described her father as being very involved in community-focused projects, including community boards and citizenship groups. Thanks to her parents' example, Justice Kagan developed an interest in both academics and law at a very young age. In her high school yearbook, she dressed for her photo in a judge's robe holding a gavel. Next to the photo is a quote from Justice Felix Frankfurter: "Government is itself an art, one of the subtlest of arts." Like her parents'
There's really an explanation for that.
Well, we
It's
didn't.
not as bad as it sounds.
We didn't have that as a question, but maybe that will now you'll have an opportunity on that, Justice Kagan. Like her parents' careers, Justice Kagan's career has consistently carried elements of public-focused ideals. Justice Kagan attended undergrad at Princeton and went on to receive a master's in philosophy from Oxford. She then enrolled in Harvard Law School, and she graduated in 1986. After law school, Justice Kagan clerked for two legendary judges, Judge Abner Mikva of the U.S. Court of Appeals for the D.C. Circuit and Justice Thurgood Marshall of the United States Supreme Court. She went on to practice at a Washington, D.C. law firm before entering academia and becoming a law professor, first at the University of Chicago Law School and later at Harvard Law School, her alma mater. Justice Kagan served for 4 years in the Clinton administration as both Associate Counsel to the President and Deputy Assistant to the President for Domestic Policy before eventually becoming the Dean of Harvard Law School. In 2009, President Obama nominated her for the role of Solicitor General of the United States and was confirmed that year. Justice Kagan argued a number of cases before the Supreme Court in her capacity as Solicitor General, including her first, Citizens United, an important campaign finance case. On May 10, 2010, President Obama nominated her to become an Associate Justice of the U.S. Supreme Court. In her confirmation hearing, Justice Kagan was highly regarded for both her practical experience and her time in public service, both echoes of her parents' careers. During that hearing, Justice Kagan noted that she owed a debt of gratitude to two other living justices, Sandra Day O'Connor and Ruth Bader Ginsburg, who had paved the way for her and so many other women of her generation. Justice Kagan took her seat on the Supreme Court on August 7th, 2010, and we are so fortunate that she has served as our representative circuit justice since 2018. Please join me again in giving a warm, very warm welcome to Justice Kagan.
Thank you. can I say before you guys begin questioning me, just a great thank you to Chief Judge Murguia, who is always such a gracious host at these events, to me, and I think probably to everybody in the room. And to the great people who worked on this conference. I mean, this program, I know Judge Liberty, you had a lot to do with it. Just a terrific program, and I wish I could have been here for all the panels. So I just want to thank everybody who worked so hard to make it happen. I really like this conference every year. You know, I've come, except I do have this feeling that my real summer doesn't begin until I get over this hour. So I'm looking forward to an hour from now where I can decide that my vacation has begun. But okay, fire away.
Okay, with that.
This is so disconcerting. You know, you have to watch yourself talking. If somebody can turn that off, that would be great.
So we are.
Otherwise, you're going to see me kind of looking up at the ceiling as I speak.
So we stand between you and your vacation. Well, Judge Liberty and I were just talking about how honored and grateful we are to be sitting on stage with you today. So
Okay.
thank you. So we'll dive right in, get you on vacation. So how, if at all, has your approach to preparing for an opinion changed if you're writing for the court or if you're writing for a dissent?
Oh, well, a good deal, actually. You know, if you're writing for the court, you have to sound sort of court-like. And that's partly a matter of style. This is something that's institutional, and everybody in your majority has to be comfortable with it. And that imposes constraints both of style and of substance. You know, in terms of style, it just, not that you can't inject your personal style into it. I mean, if you gave me 9 opinions of the 9 justices, the 9 majority opinions, and said whose is whose, I think I would do a pretty good job of identifying it. But still, you have to, you know, sound a little bit more sober and official in your majority opinions. And in terms of substance, of course, you know, you have a majority to attract. And that's in part, I have to get my five votes and make sure everybody goes along with me. But even beyond that, there is, you know, I feel an obligation to really represent the members of my majority. You know, I sometimes think of it as like, who's the median justice in my majority? And to make sure that my opinion reflects the majority's concerns and ways of thinking about an issue, and not just my own. So I think that there are, and then of course, I mean, the other difference between a majority and a dissent is like a majority has to state a rule of law. You know, you are aware that your opinion is making the law that's going to be applied by all of you folks out there, circuit and district court judges, and you have to give them something understandable and clear to apply. So all of those things are different when you're doing a dissenting opinion. I mean, to start with the last, a dissent, you know, you just have to say what's wrong with the other guy. And most of my dissents there's an aspect of the dissent that says, here's how I would have done it if I were in the majority. But at the same time, you don't have to answer every question in the way that a majority does. You can gloss over things more than you would if you were writing a majority. And you can just sort of focus a good deal of your attention on what's wrong with the other guy. Stylistically, I feel much freer. I think that that's true of most of us, that your individual writing style comes out more in a dissent, even if you're writing a dissent that you know other people will probably join, that there's just a good deal more stylistic freedom. And you know, and it can express more. This is my individual point of view. This is how I would approach a case. For that reason, I often find that dissents are more fun to write, which is, you know, even when you're incredibly disappointed that the result is the result, they are kind of fun to write. And I find them a little bit easier to write. Like they always go faster for me because I don't have to stare at each sentence and say, what are 1,000 judges across the country going to make of this? I mean, in some ways, the responsibility is a little bit off my shoulders, and I can just sort of express my views as they come out rather than sort of saying, is this going to create a problem? Is this going to create any confusion and whatnot? So it's a very different sort of enterprise. And, sometimes, when I look back over, I take both very seriously. I take my majorities, even the small ones, seriously. But I also take my dissents seriously. Sometimes when I look back over the course of a year, sometimes my most important opinion will be a majority opinion. That's what it was this year. But sometimes my most important opinion will clearly be a dissent. And, whether I know Gene Scalia talked about Loper Bright from a year or two ago this morning. I mean, he talked this morning, not that my opinion was from this morning. Just correcting my dangling whatever it was. But I could sort of go down the list, whether it's like Rucho about partisan gerrymandering or Brnovich about Voting Rights Act. There are a number of dissents that I've written that I say, well, that's the most important thing I did this year, even though it didn't create any law, because I hope that over the course of time, people will see some virtue in what I said there, and even if not, very seldom would it be like, oh, and now we're going to overturn a case, but that you can inject ideas about how to think about a range of issues into the universe that manage to get themselves felt in other cases in different ways over the course of time. And I think that that's what we all hope when we write, significant dissents.
Now, speaking of opinion writing, year in and year out, it seems as if you're writing fewer opinions than some of your colleagues. Do you want to comment on that?
I do. I fall on the lower end. We are a spectrum in terms of how frequently we move to pick up the pen. Some of us write a great many opinions, some of us many less. And I fall on the lower end of that spectrum. And, I think for a reason, and I don't mean to cast shade on anybody else, because there are different ways of approaching the judicial role, and I have a good deal of respect for my colleagues who do it differently in this regard. But I guess my point, my view is the court is that has many members in it, but it is an institution. It is a court, and it speaks best when it speaks as a court, as a single court, a single institution, rather than a place where 9 people get together and write individually. I mean, there is a way of a court operating the other way, right? You could write seriatim opinions. I think this, and I think that, and the next person thinks the next thing, and the next, and I fear that some of our opinions have begun to look like that, where it's almost like there were only 2 people who did not write in this case. 7 did. And, but I think that comes at a cost to the institution and to the way that it announces and develops law, because when that happens, I think that the clarity of the institutional message is diluted. Everybody is like, on the one hand, joining the majority opinion, but on the other hand, telling you 3 or 4 different things about what the majority opinion means. And somebody recently asked me a similar question, and I said I think as lower court judges, circuit court and district court judges, you should just kind of ignore all the concurrences, that the opinion should speak for itself, and that's what it means. And all these people sort of trying to spin it this way or spin it that way, or tell you the most important thing in it is this, or the most important thing in it is that. It's just like 1 or 2 guys, trying to tell you that they would have written it differently. I mean, I always would have written opinions differently too, but I think to speak as an institution with a single voice, it involves a little bit of flexibility and compromise. I mean, the number of times I pick up an opinion and read it and say, this is exactly the way I would have written it, the number of times I do that is approximately 0. But but I do think it's important that the court speak as a court. And, honestly, it bothers me a little bit when people do this to my opinions, like try to explain what they meant. It's like, I explained what it meant. There it is. So I try not to do it for other people because it sort of annoys me. But then the other thing about separate opinions, which I'm not altogether keen on, is a lot of separate opinions are about issues that are not before the court. A lot of people write about the next case down the road, or about some issue that was not properly presented, or about some issue that the court, as an institution, as a collective, as a majority, chose not to address. But there's still some person who says, well, I just want to say my piece. And I guess, again, this is, there are different ways of being a judge and different ways of being a very good judge. For me, I feel like my rule of thumb is if the court has decided not to address an issue, if the issue isn't properly presented, if the issue really isn't in this case, we shouldn't do it because there's not been the briefing, there's not been the consensus building, there's not been so I try not to do that too.
So this morning, we heard from esteemed members of the bar, and they were discussing the independence of the judiciary and separation of powers. And is this conversation about the independence of the judiciary sort of an echo of what we've been talking about in the Constitution, or are we in a new era?
Or are we
in a new era?
In a new era. I don't think I'm a good enough historian to be able to tell you exactly how this period relates to other periods, or there have been times in the past where there have been threats to an independent judiciary. As I said, I don't think I'm a good enough historian to tell you exactly how this fits or how it compares, how it's the same, how it's different. But I will say, it doesn't really matter to me what the history is. That's something that I say in some of my opinions. But here, it doesn't really matter to me what the history is. What matters is the challenge we face now, and I do think that there is a challenge and that there are concerns now. I thought that Chief Judge Murguia did a very good job the other day when she talked about the state of the circuit, also sort of talking about the state of the judiciary and challenges to an independent judiciary. And I would say that they're on a number of different, in a number of different areas. They're all connected with each other. One is what Chief Judge Murguia talked about, is the threats to personal safety and endangerment of judges. And that's something that my court dealt with actually a few years ago when Dobbs came down, when some of my colleagues on the majority side were confronted with protests outside their houses, including houses with children in them, and a gunman appeared at one of my colleagues' houses. And that is scary stuff. And I think now there are a number of judges sort of all up and down the judicial hierarchy that are being confronted with the same. And when it's not the Supreme Court, probably with fewer resources of dealing with that and of ensuring personal safety. And it remains really scary stuff. And I know that the Chief Justice is very committed to trying to address these issues, not only for our court, but for federal courts across the United States. So that's one set of issues. Connected to that, I think, is just some of the ways people deal with judges who, or talk about judges, or act with respect to judges whose decisions they don't like. And, again, the Chief Justice recently had to put out a statement saying, we don't impeach judges for the decisions that they make. And the chief has also, did a similar statement on the other side of the aisle, if you will, when there were attacks that really sort of vilified judges personally in ways that sort of foment this kind of, these sorts of violent threats. And judges are fair game for all kinds of criticism, strong criticism, pointed criticism. But vilifying judges in that way is a step beyond and ought to be understood as such. And then, finally, and again, sort of connected to everything else, is, this idea that litigants, and most especially I'm talking about government officials, needn't obey the dictates of courts, needn't obey court orders. And that's just not the way our system works, not the way rule of law in this country works. And that's true for the Supreme Court, and it's also true for every district court, unless and until an appellate court or the Supreme Court says otherwise, that judicial orders are judicial orders and need to be respected. Now, what that means in terms of what judges should do, I mean, some people, like, I've mentioned the Chief Justice a couple of times, have a sort of bully pulpit and can use that. But in terms of, individual judges, I think that in the face of these sorts of threats to an independent judiciary, judges just need to do what they are obligated to do, which is to do law in the best way they know how, to make independent, reasoned judgments based on precedent, based on other law, to not be inhibited by any of these threats, by the same token, not to be so aggravated or maddened by any of these threats as to do anything else, is to just sort of do law in the best way they know how. And that's to say that the response to perceived lawlessness of any kind is law. And the way an independent judiciary should counter assaults on an independent judiciary is to act in the sorts of ways that judges are required to act.
So there does seem to be some real disagreement on the court, and maybe not as stark as some commentators make it out to be. So how do you deal with that as an institution, and how do you deal with that as people?
I've noticed that there is some disagreement on the court. And the disagreement, there are different ways in which we disagree, and sometimes the divisions are one thing, and sometimes the divisions are another. But I take the point of your question to be something along the lines of there is a kind of more usual disagreement, division. That there are some number of important cases where I find myself on the losing end with two fairly predictable women. That there are some number of cases which are 6-3 cases on this court. They used to be sort of 5-4 cases. And I don't enjoy that. I find it frustrating. I find it disappointing. I find it sometimes even maddening. And I reckon, it's just a fact of the matter that this sometimes happens on cases that I care strongly about. On the other hand, I like all my colleagues. On one side of the court, if you want to talk sides, no less than on the other. I respect them. I think that they are all operating in good faith. And I think the most important thing of all is that I think that we're engaged in a collective endeavor of some importance, and that I want to participate and to continue to participate in that endeavor as best I can. And so how do I deal with that? It's like, well, you just sort of have to turn a page. And, yesterday I was frustrated, and today I'm going to engage with my colleagues who, as I said, I admire, and I think that they're very good lawyers, and try to figure out, what the next case is and what the next case is. And I think it's important that courts do that, not just the Supreme Court, but courts generally. I guess district courts, Judge Liberty, you don't have to worry about that, but everybody here, you're like the king of your own universe, right?
Until it goes to the circuit.
I think, whether you want to call it collegiality or respect, I think it's really important that people just, you lose one day and then you continue to engage the next day. And I think we all have occasion to have to do that, and I think we all do it.
So you served as Solicitor General prior to being appointed to the court. Do you find yourself engaging in an evaluation of the Solicitor Generals who come before you?
Yeah, I try not to do that. If anything, it's that I recognize that it's a really hard job. It has a lot of responsibilities attached to it, has a lot of work attached to it. I think I probably give Solicitors General a little bit of, maybe a little bit more room, just because I recognize that it's a hard job and that there are lots of difficult choices. And I've been really lucky, as has the entire court. I mean, all the time that I was on the court, the Solicitors General have been phenomenal. And that was true of, I started the Solicitor General under Obama, was mostly Don Verrilli, and then in the first Trump administration, it was Noel Francisco, and I know you guys heard from Jeff Wall, who was deputy and then took over the slot, and then in the Biden years, it was Elizabeth Prelogar. And I would say every single one of the people that I just named did a phenomenal job. They are excellent, excellent lawyers. They represented their client terrifically well. They represented the long-term interests of the United States terrifically well. That's what we sort of say in the Solicitor General's office, is like, we're representing the long-term interests of the United States. And they took their responsibilities to the court enormously seriously. So whatever it means like to be an officer of the court, and I'm not sure I could give quite a definition, but you know it when it doesn't happen. I don't think it ever didn't happen. It ever did happen. You know what I mean. Under any of those people. And so I think that the court should be incredibly grateful for the service that the Solicitors General over the years have provided. And I feel very proud to be a member of the Solicitor General Club. I just saw Paul Clement. He was before me, but I'll add him to the list of great Solicitors General because you just heard from him. And the new Solicitor General has just started. We've only heard one argument from him, so the book is still out, I guess. I mean, it's too early, but I just would expect that he would. It's a great tradition to belong to, and that he will fulfill the responsibilities that come along with the role.
So now we're going to talk about the shadow docket. And that's really not the right name. So-called shadow docket, I think you refer to it as more technically the emergency docket. But the concept of the shadow docket evokes a very strong response from court observers in one way or another. First, are you comfortable with that term? Do you like that vernacular? And then has your opinion about the appropriate use of the shadow docket changed in recent times?
I think I once used the term when I was feeling particularly, annoyed. Now I use the term emergency docket. I think that that's a more accurate term, just in terms of reflecting the fact of what it is. We're deciding things as emergencies without all the usual process that we would use. And, you know, shadow docket really does suggest that this is just a terrible thing generally, and it's not that. I mean, sometimes we have to act on the shadow docket, so there are no absolute rules here. There are some times that there are emergencies and we have to do something without all the briefing and the argument and the consultation and so forth. So I actually am more comfortable, notwithstanding that I used the word once, with the sort of more neutral term, emergency docket. I think we should be cautious about acting on the emergency docket. Sometimes we have to, but I think we should be cautious for really the reasons I just said. We get much less briefing than we would in a regular docket case. We don't have argument typically. And just as important, we don't have all the consultation. You know, we don't usually meet about shadow docket matters and discuss them in the way we do with merits cases at conference. And I think all of those things are conducive to good decision making. And so one should be hesitant about making decisions without any of those things in a way that does disrupt what's going on in the lower courts, unless, you know, we really have to. And we have standards for that. You have to have a likelihood of success on the merits. There has to be irreparable harm. I think we should apply those standards with some care to make sure that we're not doing the country's business without all the processes that we've put in place to ensure good decision making. So I think I've pretty much always thought that, you know, it's like, yes, sometimes, but be really cautious. And you know, I think I've expressed a number of times in dissents that I think that we have used it in cases where it shouldn't have been used. And I think this is a little bit inevitable. I mean, partly it depends on your views on the merits, partly it depends on how you think about irreparable harm and whether you understand interference in an elected president's ability to execute his agenda as sort of automatically irreparable harm, or whether you think it's a little bit more variable. So I think we're going to continue to have disagreements about that. But you know, I guess my own view is be cautious. I think that the thing that I have more and more come to see as we've gone along and over these last few years handled more cases in this way, and maybe this is the most important thing I have to say about this whole emergency docket issue, is the need to explain things. Because, you know, what we started doing when we started doing these things was just issuing orders. But I think that that's not the right way to approach it, because like the orders themselves don't tell anybody anything about why we've done what we've done. And I think there are some things like you can pretty well guess, but there are lots of other things where you can't. And I'll give you an example of this that happened last week. So last week there was a case which it involved a district court order. Now I'm trying to, no, it didn't come from this circuit. It was a district court order that basically prevented the president from engaging in various measures to dismantle the Department of Education. And it got to the court, and the court said, no, the district court should not have issued that order enjoining those measures. And so the question is, well, why did the court say that? And a casual observer might think, oh, the president does have legal authority to dismantle the education department. But in fact, the Solicitor General didn't even present that to us as an argument. You know, the merits of whether the president had the authority to take these steps to dismantle the education department weren't even before us. What was before us was a variety of threshold and remedial matters. So there was a question about whether the challengers had standing. There was a question about whether the court had, whether that particular court had jurisdiction over these issues. There was a question about the breadth of the remedial order in the case. And And we didn't say anything about any of those things. So that court that issued that order, like, what's that court supposed to think? You know, why did we do what we do? Is the problem that the plaintiffs don't have standing? Is the problem that the court doesn't have jurisdiction? It's just impossible to know, and that puts the court in a very difficult situation. And I think more generally, look, courts are supposed to explain things. That's what courts do. They're supposed to explain things to litigants. They're supposed to explain things to the public generally. And I think as we have done more and more on this emergency docket, there becomes a real responsibility that I think we didn't recognize when we first started down this road to explain things better. And I don't mean like we should write 50-page magnum opuses. I think, you know, 1 or 2 or 3 pages would do to just sort of say, here's the basic issue, the basic problem that we see, you know, go fix it. I mean, there was one of these emergency things came out yesterday involving a removal issue in which I dissented. I think I described the order there not as unreasoned, but as under-reasoned, which, you know, because it did have a little bit, I'll give it that much, had a little bit, not much. But here's the reason I mention it. I mean, my dissent was only 4 paragraphs long, but I kind of said what I had to say, you know. I don't think it takes all that long. So I think that we should hold ourselves sort of on both sides to a standard of, you know, explaining why we're doing what we're doing.
Do you ever change your mind when you're drafting an opinion? I mean, either generally or in a dissent?
Do I change
Or
my
after
mind
oral
when I'm
argument,
drafting?
yes.
I know that there is this sort of view of like, it wouldn't write. I have to say, I've never had the experience of being assigned a majority opinion and then like calling the Chief Justice or whoever assigned it to me and saying, I'm sorry, it won't write. I've never done that. Sometimes I draft dissents and then decide not to do them. So sometimes like I draft a dissent and say, really, is this worth saying? It just seems like a bunch of debaters' points. Am I sure I'm right? So sometimes I'll like draft a dissent to see what it looks like before I decide whether I'm right and whether you know, it amounts to much. So sometimes I change my mind on that. I change my mind about reasoning all the time when I write. I mean, I change. For me, like I think when I write, and that's when I think best is when I write. And so the writing process means that, you know, the outline in my head that I start with is almost never the outline, you know, the substance that comes out in the end, because I figure out what arguments work and what arguments don't work and how they fit together in the process of writing.
How do you think the rise in the use of AI and other changes in the legal profession will impact the courts?
Boy, I haven't the foggiest, is the honest answer to that. I once said from the bench, I think it's like the quote that most people like throw back at me, other than, you know, what I did at Christmas was not enough of a laugh there, but I said something like, you know, we're not the 9 greatest experts on the internet, and I think, like, seriously, we're probably really not the 9 greatest experts on AI. I mean, I do think that these are going to be fascinating issues coming down the road. They're new issues. I think it's going to be really interesting to see how the court as an institution deals with this, how individual justices think about them. I think it may be in ways I can't predict how people will think about these issues. I'm not sure I could predict my own way of thinking about these issues because I really haven't been presented with cases forcing me to think deeply about them. So so I have no predictions about substantive matters involving AI, and similarly, like I don't really have the foggiest about how AI will affect the actual, like our own work processes. There's a lawyer who sometimes argues before us. He's a really good lawyer named Adam Unikowski, and he has engaged in a lot of sort of experiments and with Claude, and he uses Claude for a lot of different purposes. And I got into this because he did a whole set of things with Claude to try to figure out this confrontation clause issue that I've written a lot about, and I've written sort of 2 opinions, one in dissent and one in the majority. And he sort of fed everything to Claude and asked Claude what it made of all of this. And Claude, I thought, did an exceptional job of figuring out this extremely difficult confrontation clause issue on which the court has divided twice. But so the reason I mention this is because I feel like I'm advertising Adam Unikowski's Substack. I'm sure I'm violating some rule or something, but he recently wrote this thing where he had argued a case before us earlier this term, and he basically made Claude argue the case. I don't know exactly how he did this, but he made Claude argue the case, and what he decided was that Claude had done it better than he had, which I thought was, on the one hand, sort of refreshingly humble, but I don't know. But then on the other hand, it just seems ridiculous, right? Like that Claude could do it better than you could, or that Claude could do it more to the point better than I could, right? I kind of think I'm better than Claude. So I don't know.
Well, we're down to our last question. This group really loves to hear what you've been reading, maybe what you've been streaming. So since we saw you last, what books have you read? What books are you looking forward to reading?
Well, this one I come prepared for because it has been asked every year. So I think what I've done in the past is mention a law type book and then mention some other book. I didn't know I had to do streaming, so I'll have to think about that for a second. So the law type book I'll give you this year is actually an older book. Came out 12 years ago or something like that. And the reason I read it just recently is it's by a man named Bill Stuntz, who was a great criminal law professor at Harvard and at UVA before he died in his early 50s, incredibly tragic. And I just went up a couple of months ago because Harvard is putting together a little institute or program in his honor that deals with the concerns and the issues that he thought about and wrote about a lot. And in particular, he was a serious Christian himself, and he talked about what it meant to be a Christian doing the law, and that's part of the institute. And then part of the institute is about criminal law and criminal procedure. And his great book on those issues came out actually after he died. He was working on the book all the way through his illness. And I had not read it because I was on the court at the time. But it's called The Collapse of American Criminal Justice, I think. And so after I went up to participate in this forum about Bill and about his accomplishments and about his life's work, I thought, it's just embarrassing that I haven't read this book. So I came back to DC and I started reading the book. And it is an extraordinary book for anybody who is interested in criminal justice issues. And it really sort of takes the whole history of criminal justice in this country, different regions, different eras, and tells you sort of how we got to where we got. And he has a definite, like, you may or may not agree with his views about the deficiencies of the American criminal justice system. But along the way, you learn like 10,000 things that you never knew about how the criminal justice system developed. And, you know, I just found it extraordinary. So that's my law book recommendation for you. My, here's the best novel I read recommendation is a book called Northwoods, which is by a guy named Mason, Daniel Mason, I think. And it's about what happens over the course of American history, starting from the colonial era and going through modern times, at this one particular place in rural New England where there's a house, and who lived in that house over time. And it's a book about history, and it's a book about nature and the environment and our relation to the environment. And it's kind of mystical and a little bit weird, and altogether magical. So that's my law book recommendation. Streaming, I'll give you two way different things. I don't usually watch comedies very much. I love Hacks. So if you haven't read Hacks, if you haven't seen Hacks, see Hacks. It's about this aging comedian and this much, much younger woman comedy writer who's assigned to sort of make her relevant. And it's absolutely fantastic. And then, totally on the other end of the spectrum, I mean, basically the most intense drama that I've watched for 1,000 years is The Pit. You watch The Pit? Which is for anybody who grew up watching ER, the George Clooney show, from way back when. This is like ER on steroids. It's every episode is a single hour in an emergency room, and it's totally gripping. So those are my recommendations.
Thank you. Well, thank you for being here today. We really appreciate it.
Thank you. Thanks for time.
Thank you so much, Justice Kagan. I really appreciate the time and the energy and really the focus on some very important legal issues. I know that you have to leave right away, and we appreciate you coming again this year. Thank you so much.